BlogTalk Radio.
Welcome to the AME Testing Show. Today's guest is Elliot L. Olsen, Esquire. Today's topic, a plaintiff's lawyer discussion of food safety outbreak litigation. Elliot Olsen practices in the areas of personal injury, wrongful death, products liability, medical malpractice, and foodborne illness litigation. As a recognized national leader in foodborne illness, he has lectured to a broad range of the industry, including produce growers, beef and poultry producers, and other lawyers. In 2012, he was again named super lawyer by Minnesota Law and Politics. Mr. Olsen received his undergraduate degree from Carleton College and his law degree from Washington University in St. Louis, Missouri. Mr. Olsen is a certified civil trial specialist with the Minnesota State Bar and is an elected member of the American Board of Trial Advocates. So now, join with me in presenting and welcoming to our discussion board the esteemed lawyer, Elliot L. Olsen. Elliot?
Oh, good morning. Thank you, Andy, for that introduction. Appreciate it.
Thank you for joining us today. Would you like to update us on any of your current activities?
Well, our firm, we practice nationwide in foodborne illness. We're called PritzkerOlsen, and we are involved in pretty much every outbreak that you hear about. Probably the one I'm most involved in right now is the cantaloupe outbreak from September of 2011, about a year ago. A case of listeria being spread through cantaloupe produced in Colorado. So those cases are starting to heat up in the courts now. Now that we're a year or so out.
Wonderful. Let's begin our discussion with a base question. What is a foodborne illness case?
A foodborne illness case is a case where there is an injury. In our case, we try to pursue serious injuries only where there's been someone hospitalized because of a foodborne illness. And then in turn, it has to be the kind of foodborne illness that we can trace back to a specific source, or at least a specific supplier. And most states allow us to bring an action against anybody in the supply chain, starting with the grower, or the distributor, the packager, pretty much anybody who's touched along the chain of distribution is a potential defendant. And our goal is to reach some kind of monetary settlement for our clients out of court. And if we're not able to do that, we commence a lawsuit. And usually when we commence a lawsuit, we usually try to sue as many people in the chain of distribution as possible. So, again, foodborne illness case is one that has a serious injury that can be traced back to a specific source.
Elliot, can I ask you, what is the use of governmental outbreak test results in a case in which you represent a harmed party?
We usually piggyback very heavily on the government tests. In terms of actually calling these people to testify, for example, CDC officials, there's a statute that says we cannot call them to testify. Some states have statutes prohibiting their health department people from testifying. Sometimes we can actually call the people to testify at our trial, but usually what we do to work around the problem is we go out and hire our own expert, our own epidemiologist, our own microbiologist who can analyze the government test results and perhaps conduct some testing of their own. But we get the government test results into evidence that way by, basically piggybacking it through our own experts. And we've tried to build a stable of experts usually people in academics who have studied the issues, or, for example, in the case of an epidemiologist, it's nice to find somebody who is currently working as an epidemiologist in a different state from where the outbreak happens, or someone who is, like I said before, in academia but has worked in the past as an in-the-trenches sort of epidemiologist. So it's nice to get that combination of somebody who's got some in-the-trenches experience but also, has the sort of the lack of attachment to issues that someone in academia would represent.
Well, Elliot, to clarify for our audience who are primarily food production, food quality, food safety, and food security managers, epidemiology is?
Epidemiology is the study of the origin of a foodborne outbreak. For example, if someone's blood test or stool test turns up listeria, that's a mandatory reportable illness, and the hospital or clinic that finds it has to report it to the either the county or the state Department of Health. That's the law in all 50 states. So, for example, I started to talk about listeria. We know listeria is a foodborne illness almost 100% of the time. So just knowing that we have a foodborne illness is not good enough. We need epidemiologists to look at where people have eaten, what particular foods they have eaten, and try to identify a common source, a common vehicle, a common food vehicle that could be the source of the outbreak. So epidemiology is putting together that data by interviewing people who have become ill and using that data along with the microbiology to identify the source. You don't have a foodborne illness case if the microbiology is not there, and likewise, you don't have a foodborne illness case if the epidemiology is not there.
Excellent.
So, for example, and I guess the perfect example might be, say there's listeria discovered in let's say ready-to-eat turkey meat, and then you look at that listeria and you identify its exact genetic pattern. Then you find someone who has become ill from listeria, and you look at their listeria sample and the genetics of it, and it's an identical match to that found in the plant. There's no connection there yet. You need an epidemiologist to tell you that there's a connection. Obviously, you have to clarify and prove that that person actually ate the food produced in that plant, and preferably you've got numbers. You've got a number of people becoming ill after eating that food. But again, microbiology without epidemiology is worthless, and vice versa.
Well, Elliot, that's an excellent lead-in to one of our main discussion points today. What is the technology that you use in court to narrow down that genetic fingerprint? And it leads into the question, what is pulsed field gel electrophoresis, or PFGE?
Yeah, pulsed field gel electrophoresis, or PFGE, is the gold standard right now for identifying a strain of bacteria. So let's take E. coli, for example. There are many different types of E. coli. And in fact, we as humans have E. coli in our own digestive tracts. But there's only a few strains of E. coli that are pathogenic, in other words, make people sick. One of those is E. coli 0157H7. So 0157H7 is a designated subtype of E. coli, the kind of E. coli that makes people ill. And then within that, there are many different strains of 0157H7. And it's the PFGE testing that can tell us what particular strain of 0157H7 that we're looking at. what PFGE does is it takes the DNA and it basically cuts the DNA using an enzyme at particular points, and then they are able then to compare the sequencing in the various strands that they've cut and see if basically see if it's a match with whatever other sample they're testing. Usually you're comparing something found in food versus something found in a human to see if they match up. And so PFGE is the genetic subtype of a particular bacteria. I mean, PFGE is what identifies the particular subtype.
Excellent response. And I really want, if you could, in your trial experience, compare the difference between a culture analysis and this particular type of DNA analysis of pulse field gel electrophoresis on their specificity and sensitivity from a lawyer's perspective.
By culture, do you mean something that, for example, an environmental swab that's then been grown in a broth, so it multiplies, and then you look at it under a microscope, that kind of thing?
Yes, that is commonly referred to in microbiology as a gold standard, but the pulse field gel electrophoresis offers a particularly higher sensitivity.
Yeah, and that's exactly right. The kind of testing that you're talking about, where you are taking a swab of a sample, in that case, you are simply trying to find out what kind of bacteria you are dealing with. And then, for example, you can look at the bacteria and decide whether or not it's E. coli, but to know whether or not it's O157H7 requires further testing that you're not going to get from a culture. So the culture testing is not really useful in court. I think where the culture testing is useful is in product and environment testing. So that lets you know whether conditions in your plant, in your facility, are ripe for growing a dangerous pathogen. So I think that's the value of the culture.
Very good, Elliot. Let's talk for a second about pulse field gel electrophoresis and how the government uses it.
The government uses it because they want to be able to, if you're talking about the CDC or FSIS, they're going to be using it, number one, to determine whether or not there are pathogens in the plant. But to the extent that they use PFGE, they are usually using it to decide what to do with a recall, how big to make a recall, that kind of thing. It's not used much in the day-to-day kind of testing.
Don't they have a national database that they compare and store the information from their samples?
Yes, they do, and that's a good point. When I was talking earlier about the strains of O157H7, there are known strains, and an outbreak usually comes from one of these known strains that is in the database. The CDC keeps track of the database, so that way you can tell whether or not the particular strain that you're looking at is a relatively common strain or whether or not it's relatively rare. And if it's a rare strain, that may at times strengthen your case. For a foodborne illness lawyer, that may strengthen our case knowing that it's a very rare subtype of O157H7.
So when you present that information, that there was a match between what was grown in a plant, contaminated the food product, and then you have several plaintiffs in several states with all that same genetic PFGE match, that strengthens your case, doesn't it?
Yes. Yep. Absolutely. That's the exact kind of connections that we're looking for.
Well, let's chat for a minute about what is multivirulence locus sequence typing, or MVLST.
MVLST is something that has the potential to be even more specific than PFGE. So it may be that sometime in the next 5, 10, 15 years we see PFGE go away as the gold standard and some other kind of testing come in as the gold standard, and MVLST has that capability. What multivirulence locus sequence typing, what that does is it looks at the quote-unquote virulence genes of a particular strain. And the idea that is, the idea is that if a pathogen is going to be successful, in other words, it's going to survive, it's not going to be wiped out by antibiotics, it has to evolve and change and adapt. And it's going to adapt most quickly in the area of the gene that makes it the most virulent. So MVLST looks at the virulence genes and looks for differences between two samples in the virulence genes. So you may have two samples that look exactly the same in PFGE testing and are identified as the same strain by the CDC, but MVLST may be able to take it farther and say, no, actually these two are different. If you look at the virulence genes are widely different. Therefore, we're talking about two different strains. So if you are a producer, if you're a meat producer or a produce producer, this may be the kind of testing that you want. This probably is the kind of testing that you want. If you look at it this way, PFGE may implicate you in an outbreak, but MVLST may exonerate you. So I've always told people in the industry that they should support better testing, new methods of testing, because I think that's always going to help the industry. Like I said, more specific testing can exonerate you and your product.
Well, yeah, that's an excellent point. You as a plaintiff attorney are now advocating the testing of food product prior to release, whereas many food producers feel that testing is not necessary. Have you found that response?
Well, what I've heard from producers is more why are we doing this testing if it doesn't help us in litigation? And it's true, it probably doesn't help you a whole lot in litigation, but the reason for doing the testing is to see what's going on in your plant, to find out if conditions in your plant are ripe for growing bacteria. And then if you do find that conditions are ripe for growing bacteria in your plant, how are you going to get rid of it? And when we talk about getting rid of it, we mean two different things. We mean, sanitizing the area where it's found, but then secondly, and probably equally important, analyzing where it came from in the first place. How did it enter your plant? Is it still in the plant even though we cleaned that area? Is there a certain area of the plant that harbors it? Drains, of course, are a well-known place to harbor listeria. But those are the kinds of questions that doing product testing and environment testing can lead you to find the answers and clean up your plant. So I think it's always a good thing. I think the grower, the producer, the beef producer is always going to be helped by testing their own product and their own environment.
Well, Elliot, you've kind of switched on the other side of the table. Most people feel that a plaintiff's lawyer is only arguing to protect consumers who are harmed. Now it sounds to me like you're trying to protect and giving advice to food producers on how to produce a safe product. Is it one and the same?
I would agree with that. If we stick with environmental testing. It's advice for producers about how to avoid an outbreak. Thereby meaning presumably less business for me. But I like to think that our firm is serious about preventing foodborne illness. We've made money off of it, and I think we should do something to advocate preventing it in the first place. I think that's the right thing to do. But I also advocate for certain things like better testing, because that will help us as plaintiffs' lawyers. That will help us get to the bottom of something more quickly and with more certainty.
Very good. Elliot, your perspective of being more of a crusader is more in line with, I think, the bar's perspective on remedying harm that was produced, whether it was, I can't conceive of a food producer intentionally contaminating a product and distributing it. I have to imagine that it was either negligent or some other falling below a standard of production. So my question to you is the tracking of food production from field to fork helpful for plaintiffs?
Yes, it is, because it's helpful to us in the sense that it makes it easier for us to identify the source. There are times, for example, where we can trace the source of a foodborne illness to a restaurant, but then we lose the trail there. We know it came from some kind of food within the restaurant, but we can't trace it further. Either because we may think it's lettuce, but the restaurant doesn't know where it got its lettuce from. So the chain of tracking it backward can fall apart. And for us, it's helpful if we can go all the way back, because sometimes you may sue a restaurant. And come to find out the restaurant is really a house of cards and doesn't have insurance and really has no assets, and that leaves your badly injured client with no remedy in those situations. So we want testing from field to fork, because that will allow us to identify as many people as possible in the chain of distribution, and most importantly, identify the grower, or the if it's fruits and vegetables, identify the grower. If it's beef, identify the source of the beef.
Elliot, your practice has helped many people in recovering from the damages caused by contaminated food. Can you give us some examples of food production management failures in your law practice which have led to outbreaks?
Yeah, I can give you a real good example of an outbreak we were involved in. This happened in the summer of 2002 out east, Pennsylvania, New Jersey, New York. It was a listeria outbreak involving ready-to-eat turkey meat. And that case was unique because we found, we were able to trace the product back to two plants, two different owners, but it was the exact same strain of Listeria monocytogenes. So that was odd in that it was traced back to two different plants that, as far as we could tell, had no had no connection to each other, and that might have been a good place to have MVLST testing. But let's talk about Plant 1 for example, and this is a fairly well-known company. In their cold pack area, which is where turkey breasts go after they have been cooked. They undergo rapid cooling and actual packing there. But in the cold pack area, this particular plant was turning up repeat positive Listeria tests. It wasn't necessarily Listeria monocytogenes that they were finding, because the test was not that specific. They just had repeat positives for Listeria. So that tells you that conditions are right to grow Listeria monocytogenes. But at any rate, they had these repeat positives, and they dealt with them by finding those areas where they had taken the swabs from and disinfecting those areas with bleach. And when I deposed these people, they said, well, hey, we cleaned everywhere that we found it. Every time we found a Listeria species, we got out there with a big team and really cleaned out that area. And the guy who was in charge of all this environmental testing was somebody who was a high school grad with some technical training, but probably not well trained enough. And that particular person, along with upper management, didn't bother to determine the source of the Listeria. Instead, they just said, hey, we cleaned wherever we found it. So they're not thinking big picture. The testing should be doing two things. It should be telling you what specific areas that you need to clean in, but then it should also lead you to ask that second question, why do we keep getting these positives? What's the source of this Listeria? So you need someone who's looking at the big picture, and the lesson I drew from this case and from others is that I think management folks really need to get involved in food safety, much more so than we have seen. The management people tend to be involved in sales and distribution and marketing and things like that, and there's not enough oversight for food safety. I think that would be an example of a good example of a failure in a plant, and I think it was a failure of management.
Well, your practice is more of a Monday morning quarterbacking. If you could Monday morning quarterback to that management, what 2 or 3 points could you give them as a plaintiff's lawyer to prevent future occurrences like this?
Number one, like I said, get management involved. So maybe that means, somebody in upper level management needs to know every time that there is a positive found. So somebody in upper level management, perhaps should have been told about these Listeria positives, and an upper level management person I don't think would be expected to react to a finding of one positive or multiple 2 or 3 positives over the course of 2 or 3 weeks. But when these reports of positives keep landing on that executive's desk, it's time to get involved. So I think like I said before, one lesson would be get management involved, and then secondly would be to understand what your testing means, what its limitations are, and use it to your utmost advantage. And in this case, they were doing the testing like they were supposed to, but they weren't using it to their utmost advantage. They were simply using it to clean a specific area, instead of using the testing to identify the actual source of these pathogens in their plant. So I think those would be the 2 examples that I would come back to.
Elliot, I'm going to ask you this question as a plaintiff's lawyer. If you look for in your discovery proceedings any evidence of historical records in that company of testing, and do you bring that up in the trial?
Yes, absolutely. That is, that's probably the one piece of information we're looking for more than anything is the historical number of positives. And we are aided by the government in that as well, because in the beef industry, for example, the beef industry is overseen by the USDA and a subgroup of the USDA called the Food Safety Inspection Service. So Food Safety Inspection Service, or FSIS, goes into plants periodically and does what are called food safety assessments, or FSAs. And sometimes these FSAs that we can get our hands on through a Freedom of Information Act request, will tell us what the history is of positives. Without having gotten a single document from the company, we've already got a pretty good idea of what their history is. But again, that's probably the thing that we're looking for. That's the smoking gun, so to speak. Here are these positives. Why didn't you react to them?
Well, let me ask you this question, and it's kind of a bizarre question. I have been approached by some managers, again, food production, food quality, food safety, and food security managers that say, Andy, why should we have a testing program? Because if we do find any results, then we've got to report it in a lawsuit. And if we don't have any results, it's better for us. What's your response to that?
Well, number one, in a lawsuit, you're probably going to be in big trouble if you don't have a testing program. You're going to be in trouble with the U.S. government for not having a testing program. In a lawsuit, if you don't have a testing program, we are going to, make that a key piece of our case that, hey, these people are in an industry, take beef, for example, where E. coli is a known risk, especially in ground beef, and they just put their heads in the sand, and they weren't even looking for it. So you got to have a testing program. Yes, at times you're going to have to turn over results that show you had positives in the past, and perhaps you as a company are not proud about the way you reacted to those positives. But overall, it's something that you have to do, and it's gonna help you a lot more than it's going to hurt you, and it'll especially help you if you react to those positives in the right way. Like I said before, eliminate the immediate source of those positives, and then look for the broad source or the broad problem that's going to get those pathogens out of your plant.
Well, Elliot, I'm going to ask you this final question, and we'll go on to the additional damages. That is, I have given a presentation for surveillance programs at many different types of food facilities, and one of the answers I always get is, Andy, we have insurance for that sort of thing. What is your response as a plaintiff's bar to that response? We have insurance for that sort of outbreak occurrence.
Well, I guess the first thing that comes to me is you want to do right by your fellow citizens, your fellow human beings, and so you want to be serious about testing and preventing foodborne illness. And the groups I've spoken to in the past, food producers, whoever they are, have always been very, very sensitive about that. In fact, I've found that producers know the actual names of victims in outbreaks, and they feel terrible about what has happened. But also, insurance isn't enough, and that might sort of lead into the additional damages kinds of things. And just having insurance is not really going to save you from a whole host of headaches. Number one, even if it's covered by insurance, you're going to use a lot of executive time trying to respond to the lawsuits. Secondly, I probably should have put this one first, is the damage to your reputation. In the Listeria case that I was talking about back in 2002, that facility had plenty of insurance coverage for the victims, fortunately, but the company went out of business not long after that because the folks that it supplied, wholesalers, completely lost faith in that company because of the outbreak and what the government found in that case and what we found in that case. So it can cost you your business, your ongoing business. So I guess those would be, two reasons to think that just having insurance is not enough. I mentioned executive time. For example, in that Listeria case that I was talking about, these two companies are fighting cases filed in 3 different venues: New York, New Jersey, and Pennsylvania. And that's going to add up to a lot of executive time. Also, in that Listeria outbreak, one of the defendants, the bigger one, had to go back and, by court order, had to go back and produce emails going back several years from multiple locations where it did business. And it produced, probably 400,000 pages of documents. So that really sucks up a lot of your company's resources as well. So you don't want to have to be responding to those kinds of things. I think the other cost is, if we have, I think the more foodborne illness we have, the more government regulation there's going to be. And I think most producers want less regulation, figuring they can straighten it out for themselves. So, just having too many outbreaks and too many illnesses is going to lead to more government regulation and is going to make it, potentially a lot more difficult to run your business. So I think those are some of the costs that you have to think about. Having insurance is great, but there are other reasons why you want to avoid any kind of foodborne illness claims against your company.
Elliot, you have spoken very articulately on many positions that I would expect from a plaintiff's lawyer, but you've surprised me in that many of your positions and recommendations are actually from the other side of the table on how to prevent an outbreak. What are some of your other projects and cases that have occupied your practice?
Recently, I've had a couple of cases now involving raw oysters, and there's a bacteria called Vibrio vulnificus that grows in oysters. It's not unusual to find it in oysters, and I've had a couple of clients who had pre-existing liver problems who ate these raw oysters and became incredibly ill. Two of them had to have their legs amputated and then subsequently died after that, so they died horrible deaths. But these are very preventable. Florida, for example, has regulation that requires restaurants to specifically warn customers that if they have any kinds of liver problems, that they shouldn't be eating these raw oysters. California has taken the step of banning Gulf oysters, the sale of Gulf oysters, from something like April 1st to October 1st. Those are the months where there's warm water in the Gulf of Mexico and the bacteria growth is going to be the greatest. An example of government regulation stepping in because the industry hasn't done enough. And there are ways to make oysters safe. Certainly one by warning your patrons. And then secondly, there are actual ways to pasteurize oysters without making them into something other than raw oysters. If you are going to pasteurize them, obviously you want them to look, smell, feel, taste like any other raw oyster. And there are methods to do that. There's about 3 different methods of pasteurizing raw oysters. So that's kind of a newer area for us. One other area that we've seen some growth in is, this is not necessarily foodborne, but is Legionnaire's disease. And I think there are more Legionnaire's cases now because there is better epidemiology, better microbiology on it, to be able to trace back Legionnaire's cases to their source. And in these cases, the source usually is hotels or somewhere that is using massive amounts of water and not keeping the water clean enough, thereby having an environment that the Legionella bacteria can grow. So those would be a couple of the new things that we're seeing in our industry.
Well, Elliot, I'm very impressed with your concern for both the plaintiffs, the actual damaged parties, and the producers in the food space. Would you like to summarize our discussion today in what is a food case, illness case that you have represented, what are the government tests that are used to verify the specificity and sensitivity of the organisms and their sources, and what are your recommendations for management?
Sure. Again, a typical foodborne illness case is one where we find someone who has become ill from one of the classic foodborne pathogens, E. coli, Listeria, Salmonella, and we are usually looking for cases where there's been hospitalization. And then obviously, most importantly, we have to be able to tie that illness to a food source, and that food source has to be solvent, something that we can actually get money out of. But that is our goal, to get some kind of monetary recovery for our clients. We do piggyback on government testing, and the two things that we piggyback on is the government's use of PFGE testing. Again, that's the genetic fingerprinting of a subtype of a bacteria, so it becomes very, very specific. So we piggyback on that, and then we also piggyback on the epidemiologists who are involved. So every outbreak involves microbiologists and epidemiologists. It's the combination of those two that give you a provable foodborne illness case. So, in terms of some of the lessons that I've learned, again, it's management needs to get involved in this much more so than it has. I've seen people with inadequate training who are in charge of food safety. So I think we need better education amongst those people who are in charge of it. And management needs to react when they see repeat positives. Management needs to step in at those times and make sure something is actually being done. And like I said earlier, I would support better testing methods. I think that is going to help us as plaintiffs' lawyers prove our cases, but I also think that's going to be helpful to the industry in that something that is not as specific might implicate you in an outbreak, but if you have more specific testing, that may exonerate you from an outbreak. So, again, I support that kind of testing, and I also think it's so important, just absolutely crucial, that you be doing testing of your own product and your own environment and reacting appropriately to those. So, that's kind of a summary of my thoughts on this.
Well, Elliot, I am very deeply impressed with your commitment to your law practice. It really exemplifies what I call the white knight mentality, which more fairly, I think, represents the plaintiff's bar, rather than what's been characterized in the past as someone who is just focused on extracting funds for a caused harm. And I'm very impressed by that, by the way, and your perspective of being more of a moderating factor in the industry. And I'm sure that doesn't restrict you from aggressively representing your clients as well.
No, well, thank you for saying all that. And no, it doesn't prohibit us at all from aggressively representing our clients. And given my audience here, I want to repeat what I've said to numerous other people is that I've always been impressed when I've spoken to groups of producers that they do show a deep concern for the victims of an outbreak that has originated from their facility. What I've seen is that these people in the industry actually know the names of many of the victims in outbreaks and talk about them, in terms of, we can't let this happen again. This can't happen again. So I think the industry is looking in the right direction and has a lot of good people whose hearts are in the right place.
Well, I'd like to express my appreciation for your time. There's an old saying that a lawyer's time is his stock in trade. So I appreciate your contribution to our audience of food production, food quality, food safety, and food security managers. And I'd like to ask if you would like to conclude your remarks before we close the show.
No, other than to just say, Andy, thank you for having me. Like I said, I think this is a good opportunity for us to get the message out that plaintiffs' lawyers aren't just about money, and that we do care about prevention as well. Like I said earlier, it wouldn't be fair for us to make money off this industry, yet not do anything to try to prevent foodborne illness. So I appreciate this forum very much, Andy. Thank you.
Well, Elliot, I'd like to thank you for your time again and wish you a great day. If you come up with any other topics that would be particularly of interest to our listenership, I'd invite you back on the show.
Sounds good. I hope we can do it again. Thanks again.
Thank you. Have a great day.
Yep, you too. Bye-bye.